police presence at the Rotten Row Magistrates Court ahead of Legislator Job Sikhala and Godfrey Sithole court appearance. Sikhala was in a jovial mood, throwing jibes at prison officers over their poor salaries despite reports that he was battling for life after an alleged poisoning scare. The two legislators have been in remand prison for over 83 days following their arrest for inciting public violence. Opposition leader Tendai Biti, who was at court early, called it nothing but a legal suppression of rights.
Today is exactly the 89th day that Job Sikhala, Godfrey Sithole, and the 16 members of the Nyatsime community have been detained. We find this regrettable. We find this atrocious. Some of the citizens who were arrested, who are part of the Nyatsime 16, are in fact people who were hired to transport people to a funeral, are drivers who were driving trucks that had been hired to transport funerals. So the injustice can never be more accentuated. The injustice can never be more clear. So we object to the weaponization of the law. We object to lawfare. We object to the unjust use of the law. And this is what we are experiencing in this case.
Yeah, recently Professor Maduku said the Triple C team should negotiate with ZANU-PF for them to be released. What's your comment on that?
I think Professor Maduku must apologize to all the law students that have gone through his hands. The law was created for redress, and bail is a redress. For a lawyer to then suggest that there must be political redress of a legal problem is strange. However, if he wants to make the case that there should be national dialogue among the major political actors, in particular champion-in-chief President Nelson Chamisa and Mr. Emerson Mnangagwa, then that argument and debate should be made separate from the legal issue and the legal discourse pertaining to the bail applications of Job Sikhala, Godfrey Sithole, and the Nyatsime 16.
And lastly, and why are you here today?
We had come for the ruling and determination in the case of Joanna Mamompe, Cecilia Chimbiri, and Netsai Maroa. Regrettably, we have been told the magistrate is not there, so the matter is going to be postponed.
Sikhala and Sithole made an application to have prosecutors Michael Reza and Lancelot Mutsogoti placed in prison for contempt of court. The two prosecutors are allegedly failing or refusing to provide the two with state papers. Magistrate Aurai Manuere dismissed Sikhala's application, saying no offense had been committed.
Okay, so the court made a ruling on an application for contempt of court that we had made. The application was that the state was in contempt because there was an order which was issued by the magistrate, Madam Chakanyuka, on the 18th of August, an order which ordered the state to furnish the defense with the state papers. The order specifically said that the state papers were supposed to be finished on the 18th of August 2022. The state did not comply with that court order, so the defense, through Mr. Bamu here, made an application that the state was in contempt. They failed to comply with the court order that said state papers were supposed to be finished on the 18th of August. So the state did not argue that that order was not made. They even confirmed during the proceedings that that order existed. However, today, in its ruling, the court dismissed our application, and its basis for dismissing our application was that there was no such order which said that the state papers were supposed to be served on the 18th of August 2022. Well, to us, this is shocking because that order was given on the 18th of August, and it specifically stated that the state papers were supposed to be finished to the defense on the 18th of August 2022. we are surprised that the court made a finding that that part which said on the 18th of August did not exist. In fact, the court simply said the court ordered the state to furnish state papers, and it kept quiet as to the specific timeframes. So we were actually shocked that the court came to that conclusion that there was no time frame, but it was there. Everyone was there, everyone heard it. I myself was there. Even the state confirmed that position. So we are surprising. We don't know where whether or not even that part was recorded.
So what next?
The defense, through Mr. Bamuye, made an application to have that error, which is obviously an error, corrected. The court, when it granted that order, did have the power to provide the time frame. So the defense simply made an application to say the state must provide the state paper, the state must provide the state papers to the defense, but right now that error which was specifically apparent must be rectified, in that this court today must provide a specific time frame for those state papers to be furnished to the defense. So the court said they want to inquire if they have such power to order such an application. I'm also equally shocked, to hear the court saying they want to inquire if they have such power, because last time on the 18th of August, the state made a similar application, a similar ruling. So why would the court then say we need to inquire if we have such power, when on the 18th they made a similar application and a similar finding that they have the power to order the state to provide the state papers on such and such a specific date? In our view, they simply have that power to do that, because we've got a precedent. They did so on the 18th.
So why are these papers so important? Why do you need them?
It's the accused person's constitutional right. He has to be served with his state papers so that he prepares for his defense. They are the case. The case cannot be prepared, a defense cannot be prepared without the state papers. We cannot be ambushed. The Constitution says state papers must be provided within reasonable time. That's what the defense is simply asking for. Reasonable time to have state papers so that we prepare our defense. That's it. It's a constitutional right, and they've got a constitutional mandate to do so.
Do you think these are deliberate tactics to delay trial and keep Job Sikhala incarcerated?
I wouldn't want to say much on that. I could be misquoted. But I want to implore the state to simply comply with the provisions of the law.
Sikhala's lawyers accused the state of plotting against their client because they had no case against them.
Yes, it's a deliberate strategy to delay trial. We made that application because we knew that the state did not have the state papers. The state is not ready to proceed with this matter. The state absolutely have no evidence against the two. They simply want to keep them in custody for as long as possible. They only raise the issue of having completed investigations for the purpose of defeating an application we had made for challenging continued remand. So they are coming up with story after story to challenge an application that would have made before the courts.
In another matter, Legislator Joanna Mamombe and Triple C leader Cecilia Chimbiri were in court expecting a ruling on their application of discharge at the close of the state case. Magistrates Faith Mushure, who was supposed to deliver the ruling, did not show up. The matter was then postponed to 12 September, much to the anger of defense lawyer Alec Muchadehama.
No, in fact, we were unavailable on Monday, so were the accused persons. So we proposed that the matter be remanded to Thursday, 15 September. But the state said that the matter should be remanded to Monday, and insisted, despite our protestations. So what the court simply did was to go along with what the court said. So we're not happy on that score.
The battle for freedom continues for Sikhala and Sithole, while Mamombe and Chimbiri hold their breath, hoping 12 September will bring good tidings. Chenge Tuchidi, HSTV News, Harare.